Hello, my name is Daniel Isaac, and in this short bulletin I'm going to be talking to you about some forthcoming changes to employment law. Last year, various government departments proposed various different changes to employment law, and if you're keen enough to be watching this, you're probably already aware of the proposals, so I'm going to be talking to you about implementation. The first one to actually come into effect is the increase in the qualifying period for unfair dismissal claims from 1 year's service to 2 years' service. When this was first announced, the question we all had was whether this would involve taking away rights from people who already had them. We now know that that's not going to be the case, and this will only apply to employees whose employment commences after the 6th of April. So if you are in the process of taking somebody on at the moment and you would prefer to have a 2-year trial period rather than 1, then it might be in your interest to defer the hire until after 6 April. Of course, this isn't something that you can fix by giving existing employees new contracts or delaying the issue of a contract to after 6 April, because the test will be a factual test about when they started work, not what the contract says. There is, however, a downside for employers arising from this. People who perhaps previously would have brought unfair dismissal claims but now won't be able to might seek to suggest that their dismissals were discriminatory or that they were pushed out because they were whistleblowers. And this is something that the government has been looking at as well, with the express intention of reducing spurious claims. In particular, Vince Cable has said that he wants to close what he calls the loophole that allows employees to say that they are whistleblowers simply because they've complained about a breach of their own contract of employment. When and how that will happen, we don't yet know. What we do know is going to happen is that fees are going to be introduced in the employment tribunal, and the government hopes that this will reduce the number of spurious claims. Now, there are a lot of spurious claims in the employment tribunal, but I'm not convinced that the people who bring them know that they're spurious. Most claimants, in my experience, believe passionately that their claim is entirely justified. So I'm not personally convinced that bringing in fees is necessarily going to deter spurious claims. Will it deter claims at all? Well, at the moment, the exact system is under consultation, but the proposal seems to be that if an employee has lost their job and hasn't found another one, that they will be exempt from fees. Another way of dealing with spurious claims is through costs and deposits. At the moment, a tribunal has the power to order a claimant to pay a deposit of £500 in order to continue with a claim that the tribunal thinks looks weak. That power is going to be increased so that deposits of up to £1,000 can be required. They also have the power to award up to £10,000 of costs. That's going to increase to £20,000. So lots of changes have been proposed, but very little is happening as yet. All we can really say is watch this space. Thank you very much for watching this bulletin, and if you want to keep up to date, you can follow me on Twitter @TribunalMonkey. Thank you.